morning. I hope everyone's doing well. I wanted to talk today a little more, expanding a little bit on the um, Johnny Depp trial involving his lawsuit and his ex-wife, Ms. Heard's counterclaim and defense. In particular, in the context, I'd like to talk about is defamation. So I know in the past, sometimes we've been maybe an over-reliance on study.com. So I appreciate that this is not a resource that necessarily your favorite, or at least it doesn't substitute for real classroom engagement. And I'm aware of that. And let me just go back to my preface that I always give, which is I'm always thinking of you guys. So try and tough it out for this week. Some of you I'll see this week, and I will see everyone starting next week, every day. So if we can hold out a little longer, I'll do the best I can to try and make some engaging course content, as well as we have some field trips planned next week and the following week before the end of year of this year. So I know it doesn't make up for the disruption you guys have had, but we'll do the best we can to at least get as much of that as we can. And so this is, as I said, in regard to study.com, I know it's not your favorite resource, or at least it doesn't substitute for actual classroom engagement. But I do think this particular unit on defamation is a good one, and I wanted to review it with you before I ask you guys to work on an argument I'd like you guys to make, or at least to consider making in either direction. And it's based on the Depp Heard case, and we'll talk about in just a second what I'm thinking about. So just to refresh your recollection, yesterday or the day before, you hopefully were able to put together some presentations based on how you think the opening arguments were for both counsel. What do you think they were trying to accomplish? Do you think they accomplished those things? Heard's counsel reading the entire op-ed piece for opening argument, I thought was an interesting point of view. So I'm very interested to hear what you guys think about that. So this is going to be a sort of a follow-up to that, in the sense that I'm going to be asking you to get enough background of the, sorry, I got a blip, get enough background on how defamation works, and then I'll be asking you a question about based on what you were able to research and understand in regard to the trial. All right, so first, let's talk in general about what defamation is. Defamation of character is any, as noted here, any written or spoken and intentionally false communication. That's key here. Defamation does not apply if it is true. Saying something that is true that harms somebody is never considered to be defamation, or at least not defamation that allows a recovery against the person. Telling the truth in our country has had a great reverence due to our reverence for free speech, and it's always been part of what free speech advocates, and certainly I would include myself among them, would say is important to distinguish us from, say, an autocracy, where speaking bad things about a leader, whether true or not, might be considered to be treasonous or seditious in some fashion. And we have shied away from that notion in our history, and we continue to do so going forward. And so the truth is always an absolute defense to defamation. Okay, so it's important in that respect to understand that it has to be false. Okay, it's generally intentionally false, or the person who engages who publishes the content is reckless as to its truth. And we'll talk about some ways in which courts decide those things. But remember what the tension here is. The main tension that we're talking about is a tension between freedom of speech, which not only do we want to encourage people to speak, we don't want to discourage them from speaking by making them vulnerable to lawsuits unless we think there's a compelling public interest to do so. People should be allowed to say things, particularly things that are true, or at least that they see are true, even if they damage other people, right? And that's one of the some people that have described, for example, some issues with social media, say that to some extent there's part of the price of free speech is that you will sometimes be offended by what you hear. So that's the tension I want you to be aware of. Is courts, on the one hand, they want to balance free speech, which we revere, on the other hand, preventing people from speaking in a way that harms other people. Okay, so that's key. So here's the example that we're looking at here. Sandy posts a picture of her ex-boyfriend smoking marijuana. Fran's offer to attend West Point is rescinded, and he calls the center to help smooth things over. The senator refuses to help Fran. Okay, so Fran in retaliation sends a retouched picture of the senator kissing someone who is not her spouse to his freelance photographer cousin. They send it to a tell-all website, the Megaphone. The Megaphone believes it to be true, so they publish it. Consequently, she has an ethics charge brought against her. Fran sues Sandy for posting the picture, and the senator sues Megaphone. Okay, now, one of the things that may come up in this, and we'll talk about it going forward, can the senator actually sue Fran? And we'll talk about that, okay? But let's talk about these two cases first, these two hypotheticals. So the senator sues Megaphone, who is the publisher of the picture, the fake picture, but they believe it to be true, okay? And one of the things I hope Mr. Catch will be able to talk to you about is what sorts of due diligence a reporter will engage in before they publish material of this kind. Hopefully he had a chance to bring his vast experience to your advantage when he talked a little bit about op-ed pieces. And in regard to this case, the Depp Heard case, Heard's op-ed piece that was published in the Washington Post. So hopefully Mr. Catch has been able to give you some background information on how op-eds are, who publishes them, why they're published, and the sorts of things that the paper will do, engage in what we call sort of due diligence to make sure that the op-ed's not going to be a problem for them for a variety of things. And so in addition, perhaps he'll be able to comment in regard to this photo. What's the sort of thing that if he were working for Megaphone, what are the sorts of things he would do to try and make sure before he publishes a photo of a senator, particularly a standing U.S. senator, what sorts of things would he do to make sure that things are bona fide, and how protected would he feel in this situation? But in regard to the legal case, if the senator sues Megaphone or if Fran sues Sandy, in neither case will there be a recovery. And let's talk about why. Okay, so even though Sandy does publish a photo of Fran smoking marijuana, which leads to him losing something of value, which is this offer to attend West Point, she can't be sued successfully for defamation. And likewise, Megaphone, which did in fact publish a phony photo of the senator, can't be sued successfully, although a lot would depend on what they did to make sure that the photo was genuine. And hopefully, as I said, Mr. Catch will be able to talk a little more about what sorts of things they'll do to try and make sure. But let's assume, for the purposes of this discussion, that Megaphone did everything they could not to publish a what they believe to be a fake photo. That they did everything they could to make sure that they thought it was real and legitimate, and there's enough evidence to support it. Okay? So in that case, both defamation cases lose. Fran can't sue Sandy, and the senator can't sue Megaphone. So why is that? All right, let's talk about it. So first, what is defamation of character? We talked a little bit about it already, but I'll just say again. Intentionally false communication made by someone that harms their character. If communication is written, it's called libel. If it's spoken, it's slander. Now, in the modern social media age, sometimes those two become conflated, but understand that written material is called libel, spoken material is called slander. What the internet is considered actually is mostly libel, but on some occasions it can be known as slander. Okay, and we'll talk about maybe some more examples if we going forward when we talk a little bit more about media literacy and defamation and free speech and so forth. All right, so that's what defamation in general means. As noted in the outline here, the communication can be in any form, including social media, and it must be seen by at least one third party who's not the target of the communication. Okay, so an email sent to one other person in your family, for example, would not be considered sufficient grounds for defamation of character because it's not intended to become public. Okay, the medium used can be used written word, voice, video, picture, and so forth. Okay, so let's talk about these two cases. The first case we're talking about is why would Fran and the senator both lose? Well, in Fran's case, and just to refresh your recollection, Fran is suing Sandy for publishing a picture of him smoking marijuana. Okay, if it's for the purposes of this discussion, it's a true photo. Okay, meaning he was smoking marijuana and she took a picture of it. So the truth is always an absolute defense to defamation. Defamation has to be false, or at least the person who releases the information has to be careless of its truth. All right? So in this case, no recovery. Fran's mad, sues Sandy. Fran has actually lost something, has been damaged by the release of this information, so there's no question about damage, because damages is one of the things you always have to prove in a civil case. Not only an act that someone does that is wrong, but the wrong actually does damage to you. In this case, actually can prove damage, that he's lost something of value. Okay. All right. So what about the senator? Why can't the senator sue Megaphone? Well, assuming Megaphone did everything it could to make certain that the photo was genuine, okay, as long as they weren't careless of the truth of it, as long as they are in good faith and have good reason to believe that the photo is correct and genuine, okay, one of their defenses is that they are not defaming her because they are telling what they believe to be the truth. Okay, so that's the one of the aspects that makes their lawsuit problematic. The second thing that makes their lawsuit problematic and probably will lead to loss has to do with the nature of the senator. In his case, the notion that she is what is called a public figure, which both Johnny Depp and Amber Heard are both public figures in this context. And usually, we won't get too much into too many definitions of public figure. Mr. Katz might be able to give you more information on that based on his experience in journalism as to what a public figure is. But in the law, it tends to be someone who holds himself out to the public as a public figure. It tends to be as simple as that. And celebrities almost always qualify. Okay? So one of the things to realize is that a public figure actually has less of a defense against defamation than an individual private person. That is to say, it is much easier for a private person to sue for defamation than it is for a public figure to sue for defamation. There is an additional hurdle they have to overcome before they can get a recovery against someone who has defamed them. Okay? So the case we are looking at here is New York Times versus Sullivan. In this case, Sullivan was the city commissioner in charge of the Montgomery Police Department. New York Times actually took out an individual ad within the newspaper, accusing the Montgomery Police Department of ulterior motives, in essence, accusing them of being racist and for some other things as well. And I'll try and put a copy of that for you guys to be able to see it because it's rather an interesting ad. But the accusation was that they had for bad cause, essentially, with bad motivations, arrested and charged Martin Luther King Jr. for perjury. Okay, and they, of course, the advertisement of the New York Times was they did this intentionally to prevent him from moving forward on his attempted policy initiative to integrate public office and to allow black citizens to vote. I mean, they had the right to vote, but it wasn't really encouraged. And more importantly, to open public offices to black office holders, which was extremely important at the time. So Sullivan, who was the city commissioner, who was in charge of the police department at that point, sues for defamation. Okay, wins at the trial court a settlement for $500,000 in state court, and then the defense appeals. New York Times. The New York Times argues that there ought to be a different standard applied to Sullivan because he's running for public office, and therefore he qualifies as a public figure. The Supreme Court agreed and said, you know what, public figures, because they are holding themselves out to the public as a public figure, running for office being one way to do that, being a celebrity is another, have to expect that they are more vulnerable to being mocked, made fun of, but also questioned in terms of their motivations, in terms of their policy initiatives, and that rightfully ought to be so, and part of a protected free speech system that allows the public to give and state their opinions in regard to public figures. And so, in addition to proving that something was said that was actually false, they also have to prove, and when I say they, I mean public figures, in order to recover in a defamation lawsuit, have to prove that if someone published something that harmed them, they did so with what is called actual malice. And that's key here. It has to be actual malice. Okay? Sullivan wasn't able to prove it, of course, and so he lost. But it's clear that the court may put a lot of stock in the notion that once you make yourself a public figure, you open yourself up to criticism necessarily. All right. So this is part one. I'm going to continue this discussion in just a second, and I'll be with you in part two.